Good afternoon. My name is Brandy Beltas, and I'm an attorney who practices bankruptcy law in downstate New York. This is Westchester, Long Island, and New York City. Um, I just want to discuss with you some of the basics of bankruptcy law um, and what happens during the bankruptcy process. Typically, what happens when a person contacts me to discuss bankruptcy, we meet to discuss how much they have in assets, what their liabilities or their debts are, and how much they have in income. With these three factors, my office is able to determine what type of chapter of bankruptcy they should file. There are four different types of bankruptcy, but the two most popular for consumers are Chapter 7 and 13. The differences between Chapter 7 and Chapter 13 is that a Chapter 13 has certain debt limits. Chapter 13 requires the debtor to pay off some of their debts, and it also is established that the debtor has some discretion to income in order to pay off these debts. A Chapter 7 is simpler. It is typically when a debtor does not have enough discretionary income to pay off their unsecured debts. They don't have the debt limits of like the Chapter 13 is, and it's usually much quicker. With both chapters, it can be for consumer debts. It can also be for business debts. I represent both. Before a debtor can file the petition to get the bankruptcy case started, they have to participate in a bankruptcy class. After the bankruptcy class is over and they get their certificate, the petition can be prepared by the law office and then is filed with the court. Within a couple of days after the filing, a trustee is appointed to the case. The trustee represents the unsecured creditors. What they're doing is they're looking for assets. This is any sort of property the debtor has that is considered not to be exempt by the state or by federal law, depending on what types of debts a person has. When the trustee is assigned, a 341 meeting is also set. During the 341 meeting, the debtor will meet with the Chapter 7 trustee or the Chapter 13 trustee with their attorney and discuss how much the debtor has in assets, how much they have in liabilities. During the meeting, a creditor is also allowed to show up. This very rarely happens. And then after the meeting, then the trustee decides, with the Chapter 7 proceeding anyway, whether the debtor has any assets. If they find that the debtor does have assets, then they file discovery of assets, and it allows any of the creditors to put in claims for the debt they believe the debtor owes them. If they find that there are no assets to distribute, then they state that there are no assets to distribute, and they recommend for the court to close the case and to be removed from the case. When this happens, the judge will discharge the debts. This means that the relationship between the person and the debt is severed, so that any creditor can't go after the debtor personally. If you have any additional questions about bankruptcy, please feel free to give me a call. My office is happy to provide any information you need. My phone number is 914-294-4844. If you are a union member, please let my office know. We do a lot of work with unions. We'd be happy to provide you a discount. I hope this has been helpful for you. Please be advised this is for information purposes only, so it does not establish any sort of attorney-client relationship between my office and the viewer. Enjoy the rest of your day.